All right, good morning, everybody. If you are coming in, we're going to be talking about the SCOTUS opinions that are going to drop today. So, we don't know what they're going to drop, and we have 12 cases left for them to issue. I firmly believe that they will not be issuing all 12 rulings today, likely going to get a decision day next week as well. But if they do drop all 12 today, I'm going to be suing, saying that they're trying to unalive me. I can't read all that out to y'all. Now, SCOTUS blog, if you're over on SCOTUS blog, I totally get it. That's also a really great, it's way better than me. But if you are here, I love you and I appreciate you for being here. Sorry, I'm just trying to share this out to all the peoples and some of my mods so they can come in here. But anyway, so we got a couple of minutes before they're going to start dropping decisions. We'll see where we're at. I have SCOTUS blog in 2 tabs open because I also use them. We do not have a date officially scheduled for next week, but they hate me if they drop all 12 today. So we're going to go over the 12 that we need. We got a few cases previously that we had talked about, but these are the cases we are waiting for. So we have the Trump v. Slaughter case. This was a big case where Trump just kind of summarily dismissed an appointed position. And it was the Humphreys executor, I believe, that was the challenge there. But yeah, it's whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers, and if so, whether Humphreys executor v. United States should be overruled. And 2, whether a federal court may prevent a person's removal from public office either through relief at equity or law. Then, this one is the case I've been waiting on that I believe has been swept under the rug. Just hot tip here. The National Republican Senatorial Committee versus the Federal Election Commission. Hi, Googs. I love you all. Thank you so much for coming in. This was the one where whether the limits on coordinated party expenditures violate the First Amendment, either on their face or as applied to party spending in connection with party coordinated communications. So, okay, let's talk about that for a hot second. It's just basically Citizens United 2.0. Parties want even more control about the money that they're allowed to spend just willy-nilly. So we got that one. That's the one that nobody's talking about that I think everybody should be talking about. We also have the 2 cases that were heard on the same day. We have Little v. Hecox and West Virginia v. BPJ. Both of these revolve around 14th Amendment sex protections under the 14th Amendment. Whether laws that seek to protect women and girls' sports by limiting participation to women and girls based on sex violate the Equal Protection Clause of the 14th Amendment. And then the West Virginia versus BPJ also throws in Title IX. So we're going to be maybe getting those 2 today. I don't believe that's going to be a favorable decision for people that, are based in fucking humanity. But I digress. We're also waiting on Wolford v. Lopez. This is a 2A case from Hawaii, where Hawaii wanted to put in black laws as historical precedent under Bruin. And black laws are exactly what they sound like. They were used previously before, they were found to be unconstitutional on their fucking face, to disarm black people. So yeah, we have that one. That one will be favorable to the 2A community, I believe. We have Trump v. Cook, very similar to the Trump v. Slaughter case with dismissal, only not factoring in the Humphreys executor. And it's whether the Supreme Court should stay a district court ruling preventing the president from firing a member of the Federal Reserve Board of Governors. Good morning, everybody coming in. I'm just going over the cases we're waiting on, and we will get into these in just a minute. That's Watson v. Republican National Committee. This is the Do mail-in ballots need to be in by federal election day, or do states like have the ability to regulate their elections? Crazy shit. Mullen v. Cholato, whether an alien stopped on the Mexican side of the U.S. border is in the United States for reason of application. That one's not going to go. They're just not. That's just how that works. Birthright citizenship. I think that may be one of the last decisions. We may not see that today. I don't know. We have the Monsanto v. Durnell, which is our Roundup case. Chattery v. United States, geofence warrants, big deal. Mullen v. Doe, and then there's also another tied case to that, which is whether the Trump administration can end TPS, which temporary protected status for Syrian nationals, but it's also addressing Haitian nationals as well. So there's actually two cases, but they're lumped under one. So anyway, let's get after it. Let's start refreshing because it is now 9 a.m., baby. And let's see if Scotus Black can tell us the first one. Nope, we don't have anything yet. So, opinions of the court. Let's see. All right, we're going to start refreshing and waiting for them to drop their decisions. Let me refresh this as well. Maybe we've got something new in the chat. Public is waiting. Sorry, I'm trying to see if Amy can tell us which. Okay, she hasn't told us yet. Apologies, guys. I'm just going to keep refreshing. And we're waiting. So, you know, this is always the fun part of everything. Let's see. I'm trying to see if they know. Because it's just barely 9 o'clock. So, guys, they're not in any particular hurry. They're law clerks. I really think that they have a vendetta against me when they're uploading this. Like, just fucking upload that shit. Like, it's no longer a secret when they've dropped the decisions. I don't need to wait for them to read them out. We've got Monsanto v. Durnell, our Roundup case. Monsanto Company manufactures and distributes Roundup, a glyphosate-based herbicide designed to control weeds. The EPA repeatedly evaluated glyphosate, I guess. I don't know. Sorry, I hope I'm saying that right. And repeatedly concluded that glyphosate is not likely to cause cancer. The EPA's assessment is shared by many other regulatory bodies around the world. In accordance with the EPA's view that glyphosate is not likely to cause cancer in humans, EPA has not required labels on glyphosate-based pesticides like Roundup to include a cancer warning. In 2019, John Durnell sued Monsanto in Missouri State Court, alleging that he had used Monsanto's Roundup products for about 20 years and that they had caused his non-Hodgkin's lymphoma. I'll tell you why this case is important to me. It may not be important to everybody else. My grandmother also had non-Hodgkin's lymphoma, and my dad has chronic lymphocytic leukemia. They can say whatever they want. There's a connection. Anyway, as relevant here, Durnell brought a failure to warn tort claim, asserting that Monsanto should have included a cancer warning on the Roundup's label. A jury agreed and awarded Durnell more than $1 million on the failure to warn theory. On appeal, Missouri Court of Appeals affirmed. The Court of Appeals rejected Monsanto's argument that the Federal Insecticide, Fungicide, and Rodenticide Act expressly preempted Durnell's failure to warn claim. This court granted certiorari, held the Federal Insecticide, Fungicide, and Rodenticide Act expressly preempts Durnell's state law failure to warn claim because the claim would require Monsanto to add a cancer warning to Roundup's label. Because fuck them, that's why. I hate this court sometimes. And it's not even that necessarily that, like, I just feel like we have to have better protections for people. Anyway, we're going to keep refreshing and see what else we get. I'm not going to opine on that decision too much because it's just like, right now, it's I know we're waiting on bigger shit, but I don't personally like the outcome, but still shitty. I don't know. Okay, they better not take. Are you ready for the Humphreys executor to be overturned? Spoiler, I will tell you that was one of the hardest cases of the season for me to call. I've been pretty accurate on almost all the decisions we've gotten, and that one was so, it was very hard for me to judge where they were going to go with that. Maybe, maybe not. That's where I'm at with Trump v. Slaughter. It's a maybe, maybe not. But I think it'll be a tighter decision. Did you discuss? I did discuss Cisco v. Doe. We're waiting on Scotus decisions, and they take forever. So if you are here and you are sitting through this with me, you are amazing. I know it's kind of frustrating to wait and watch. And thank you so much for all the gifts. Y'all are so amazing. I appreciate every single one of you so, so much. Barbara, I think so. They have 12 decisions left to drop and don't have another decision day scheduled. I think we may have one Monday or Tuesday of next week, but since they haven't officially announced it, oh, Wolford v. Lopez, baby. I've been waiting on this one. This is going to be good for the Pro 2A community. That was my prediction. Let's see where this goes. For years, the state of Hawaii made it impossible to obtain a license to carry a firearm. 4 years ago, however, this court held in New York Rifle and Pistol Association v. Bruin that the Second and 14th Amendment protect the right to carry handguns outside the home for self-defense. Hawaii responded by replacing its old law on carry permits with new laws that achieved similar results. At issue in this case is a Hawaii law that prohibits firearms on private property open to the public without the express affirmative consent of the property owner. This is kind of it's very much the vampire rule. To enter, for a vampire to enter your home, you have to give them permission. That's what this is. Okay. So anyway, Hawaii's new rule imposes severe restrictions on the daily activities of the residents who have satisfied the state's rigorous requirements for the issuance of a carry permit. When these permit holders leave home, not only must they take care to avoid all territory where the possession of a gun is prohibited outright, but they may also be barred from entering many places that people routinely visit in the course of their daily routine, such as gas stations, restaurants, and stores. This law flips the default rule at common law, under which anyone has an implied license to enter property held open to the public unless the property owner withdraws consent. In DC v. Heller, this court held that the Second Amendment protects an individual right to keep and bear arms within the amendment's central concern being the fundamental right of self-defense. Heller instructed courts to ascertain the scope of the right by looking into the history and emphatically rejected an ahistorical, judge-empowering, interest-balancing inquiry. The court later held in McDonald v. Chicago that the Second Amendment right applies equally to the federal government and the states through the 14th Amendment, settling the question whether the Second Amendment embodies a uniform national standard or one that varies from one locale to another. In Bruin, the court fleshed out the process of historical analysis required in the Second Amendment case, holding that the analysis involves two steps. First, a court may determine whether the challenged law falls within the plain text of the amendment's language by asking whether the law applies to the people and restricts the keeping or bearing of arms. Sorry, they have all this weird stuff in here. If a challenged law falls within the plain text, it is presumptively unconstitutional, and which means that it may violate the pre-existing right that the amendment codified. But the government may show that its challenge law did not infringe on the historical understanding of a codified right. Sorry, I'm Law. You're very welcome to come up if you would like to. While a variety of sources may aid in this inquiry, the best evidence is often what Bruin called historical analogs, old legal rules from which a court may draw a strong inference that the modern law I lost my place, at issue is consistent with the codified right. Bruin identifies three important inquiries for evaluating proffered historical analogs. The number of jurisdictions in which they were adopted, to the extent to which they were well accepted, and whether any analog or collection of analogs is relevantly similar to modern law in terms of how and why it restricted the keeping or bearing of arms. Petitioners, 3 residents in Maui County who possess concealed carry permits, and organizational plaintiff with members who have such permits, filed suit in federal court seeking temporary permanent injunctive relief, contending that the law at issue violates their constitutional rights. The district court enjoined enforcement of the law as applied to private property open to the public, but the Ninth Circuit reversed. All right. So here's what it held. Hawaii's law prohibiting licensed concealed carry permit holders from carrying handguns on private property open to the public without the property owner's express authorization violates the 2nd and 14th Amendments. That's what we got. So essentially, if they're saying that you can't enter unless you have that express permission, they don't get to do that shit anymore. And I love that for them because I think that's a crazy rule. Oh, thank you. Sorry, I didn't see if you were requesting, so I apologize. I'm not following.
Yeah, Google invited me, so.
Oh, okay. My bad. I'm sorry. Are you in court? Because we can let you go if you got it.
I've got Zoom court today, so I'm multitasking. So if I go quiet for a little bit, it's because I'm on the record.
No, you're good. Any thoughts on this one? That was a pretty nice drop. I mean, I kind of expected this one more than Hamani, but I'm here for it.
Yeah, I mean, this one, I was expecting Hamani to go the other way or be very extremely narrowed. So, that was interesting. No, I mean, you did a good job recapping it. The controversy here is that Hawaii decided to pass a law, and a couple other states have subsequently, that, generally, if you're in a state that has carry permits, every business has some sort of a mechanism to put a posting up that says, we don't want your firearms in here. What Hawaii said is, basically overtook that implied consent of the business owners and told them that they have to affirmatively tell people that they're allowed to have firearms in their business in order to allow them to carry in. There's some problems there. Compelled speech, for example, that argument was made but didn't survive on appeal. But the idea is, if you have a business owner that doesn't care, that it's like, I don't want in this. Yeah. I don't want to tell people they can carry. I don't want to tell people they can't. I just let people do what they want to do. Hawaii is basically forcing them into action, saying, hey, if you want to allow these customers in, then you have to put up a sign, which might have some consequences for them. I think the overwhelming number of business owners were apathetic to this. And then during the oral arguments, they were saying that essentially this prohibition would make it illegal to carry in like 90% of the buildings in Hawaii by default.
Well, and I'll tell you, this was one of the few cases where the attorney for the government, I forget, it was a woman, and I can't remember her name. I can't remember who it was. She did such an amazing job. She made so many good points. And like when they were like talking about black laws that were, sort of proffered by, Hawaii here, she was like, no, they were always unconstitutional. Like it was just she did a really really good job. Usually, I'm not very fond of like this sort of Trump, solicitors arguing, but she was actually really really good. I thought she did a really good job at arguing this case in particular. Um, so we have Mullen v. Al Cholato, which is if you're on the Mexican side of the U.S. Mexico border. I was gonna read that off real quick. Did you have anything else on the what you call it? I can't remember the name of the case. The Hawaii one right now. Sorry.
Wolford v. Lopez. I'm just looking through the dissents right now. Looks like Kagan is saying she would have upheld the law because there were modern colonial era foundings that required an owner's affirmative consent before they could carry a firearm onto property. I don't agree with that one necessarily. That had to do more with hunting, and that was more of a concern about taking game rather than possessing a firearm.
Exactly.
Yeah, yeah, if you want to come in and hunt my animals, you have to get my permission. It wasn't you can't have a firearm on you. And Jackson dissent joined by Sotomayor. Looks like she's arguing property rights. No one has a constitutional right to enter property without the owner's consent. Yeah, but there's always been implied consent rules. Like you don't need somebody's consent to go and knock on their door if you're having an open house. Like a business is more like if you're going to go with residential analogs at the time of the founding, a business is more like an open house. Somebody is showing their property at an open house more so than that. So yeah, I mean, based off of the framework that we have under Brune, this is the right decision. So you can agree with that framework or you can disagree with it, but
Who wrote the decision? Was it Thomas or was
Alito.
It was Alito. Yeah, I was like, this is a little wordy for Thomas. I was speculating maybe it would be Alito, and okay, got it.
Hey, Oscar, good to see you. And
Uh,
Michael.
Oh, hi, Oscar. Sorry, I just caught your live the other day. It was wonderful to watch. You did a great job. Oh, Michael's here. What up, Michael? Anyway, so okay, we're gonna go through Mullen v. Al Ocholato. I told y'all how this decision was gonna go, and indeed I was correct, but we'll read it off here. The INA of 1952 governs the process by which an alien who arrives in the United States is inspected by border officials, is deemed an applicant for admission, and may apply for asylum. The question in this case is whether an alien who seeks to enter the United States from Mexico arrives in the United States within the meaning of that phrase in the two key INA provisions, 8 USC 1158 and 1225, when the alien is standing in Mexico at the border, or only when the alien crosses the border and enters the country. I won't go through this because whoever wrote this was also wordy, but I will read you the holding. And again, I'm going to say it. We already knew. An alien standing in Mexico does not arrive in the United States by attempting and failing to set foot in this country. An alien arrives in the United States only when he crosses the border. The INA thus neither entitles an alien standing in Mexico to apply for asylum, nor requires an immigration officer to inspect him. Let's see who wrote this. Alito delivered the opinion of the court, which Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett joined. Thomas filed a concurring opinion. Sotomayor dissented. So it was very much, on the perspective that we know it. So we kind of already knew that was going to happen. But that's what we got. Let's see. What else did they... Really? They still haven't dropped the next decision? Let's see.
Yeah, I've been refreshing too. Yeah, so this Otro Lotto case, This had to deal with custom CBP. They had a metering policy at the ports of entry that limited the number of asylum seekers every day. And then what would happen is the CBP would stand on at the border and prevent people from coming in once the capacity was reached. And I think those are some of the bad facts that led to the outcome of this. Is that, you know, is it consistent with the law to limit the number of asylum seekers? Even Biden did a executive order that shut down the border once a capacity was reached. So they're asking whether or not they're considered arriving in the United States was the key term that was in dispute. There is, if they're trying to arrive to the United States and they're blocked by a government official, have they yet arrived in the United States? They're at a port of entry. And basically, they just went with kind of a hypertextualist cop out, which really opens the door to saying, okay, we're going to allow 10 asylum seekers a day, and then put CBP officers at the border and turn around everybody else who's trying to apply. But this was kind of what you and I both thought, that they were going to come down on some hypertextualist language.
All I'm saying, law baby, we're 3 for 3 today. We nailed them all.
Yeah,
Monsanto, Mullen, and Wolford, we nailed them all. So that's all I'm saying. 3 for 3.
I'm looking through the dissent right now. So this was Alito again. They gave Alito 2.
Well, my bigger thing is that with Alito, the only other two that would be riding are going to be what? Thomas and Roberts, correct?
Well, it goes in reverse senior, or it goes in order of seniority.
Yeah.
We're going to get the opinions from the most senior judge. So we're not going to get any opinions from Roberts, which means I doubt birthright citizenship is coming, because Roberts is definitely going to be writing that
You
one.
think so?
Yeah, they're not going to give that one to a junior judge. And then Monsanto was written by Kavanaugh. So all that we have more junior than him is Coney Barrett and.
Well, but I thought it actually goes reverse that. I thought they released the most junior justices first and then go up. Am I backwards? I'm probably backwards today. It's all right. My bad.
Now you got me doubting myself.
No, you may
No,
very well be right.
I think you're right. I think you're right.
Yeah, I think it's only Roberts or Thomas left, correct?
Yeah, it would be. Yeah, if it's Alito, then it's Roberts or Thomas, which means it could be birthright citizenship, which might be why we're waiting so long.
Well, but also we're still waiting on Trump v. Slaughter. We're waiting
Yeah,
on Trump v. Cook. So those are two kind of, and then we're also waiting on the mail-in ballots case and the money in campaign finance case. So we've got a lot of bigger cases that are coming.
yeah. Let's see. I'm going through the dissent now. Sotomayor, joined by Kagan and Jackson. The majority focused on the word "in" and ignored statutory context. Yeah, well, that's what textualists will do.
So there were only 2 boxes today. But this is apparently taking much longer than usual, according to Scotus blog. So I don't know what they're about to drop, but I'm suing for intentional infliction of emotional distress. I just need to let you know that as you're my attorney. Thank you so much.
I look forward to our very
Oh,
prompt dismissal.
we got the last one. Mullen v. Doe.
Oh, here we go.
Another Alito opinion. Fuck my
What the
life.
fuck?
Okay. They will have more opinion days next week, guys, because they have 12 cases left. So we may be going really sort of edging up to July 4th, which I think is a Friday. So the question presented is whether respondents who challenged the termination of temporary protected status for aliens from Syria and Haiti are entitled to orders postponing the terminations during litigation. Congress created TPS in 1990 to provide short-term humanitarian relief for aliens who cannot safely return to their home countries. Although designed to afford temporary relief, TPS designation designation in practice have often lasted for decades. Syria received a TPS designation in 2012 because of extraordinary and temporary conditions. All right, we already know where this is going to go. I don't need to read this off much longer. This is Alito dog shit. So the TPS statute bars judicial review of non-constitutional claims. That's the holding. You want to explain that to us, Law? In a way that
Yeah,
only you can.
I'm reading real quick. Secretary of so 2025 Secretary of Homeland Security issued notices terminating the designations. The termination. Haitians brought Administrative Procedures Act on equal protection, and that the termination was racially motivated. And court held that the section 1254 of the 8 USC, so the INA, bars judicial review of any determination concerning TPS designation. So basically, it's that the courts have no authority to review the status. So again, it's another textual decision. And then so the court didn't apply Arlington Heights equal protection framework. That's interesting.
There's
And
no raw
Thomas,
dog in it.
yeah, Thomas wrote a concurring saying, that aliens have no equal protection rights.
Nobody ever would have expected Thomas to. Sorry, I'm just fucking talking shit. Go ahead, Law.
Yeah. That they have no equal protection rights against the federal government in this context, because essentially once their TPS status is terminated, they have no relationship with the federal government anymore. That's pretty interesting. That's like saying I got fired, but I can't sue my employer because I'm not employed there anymore. That's a little silly.
Okay, but hear me out. Hear me out. I have a conspiracy theory right now. Did they drop all the Alito dog shit today because they're about to release some decisions that Trump is really gonna hate next week?
That could be. I mean, this is his fourth opinion of the term.
He's a fourth or fifth.
Because he did Pung,
Yeah.
and then he had 3 today, right?
Yeah, he had another opinion earlier though in the term, I believe. I'd have to look, but
I think that's Pung. So we've had 10 opinions then, and he's written 4 of them. He's not going to get another one.
That's good for all of us, because I know some people.
Cass, be careful, you're going to get a flag.
Some people love Alito as a writer. I cannot stand him. In fact, hate on me if you want. I love opinions written by Thomas, and he's talked about how he writes opinions, and I like it because he says he writes it for the common man. He wants somebody to be able to understand what he's saying in his opinion. Love him or hate him, I like the way he writes opinions.
Alito's basically like your racist grandpa who sends Facebook forwards Facebook messages, but he has an Ivy League education, so he says all of the racist shit. He just says it a lot more eloquently.
Yeah, no, that's such a good way to describe it. I can't even that's perfect. It's like the Karen at the school who wants to kick out all the black kids, but is doesn't say that. That's the vibe it gives. Yes, very much.
Yeah. So Kagan wrote a dissent, which I'm definitely going to dive into. Kagan's by far the most skilled writer on the court.
Man, coming for Thomas now? No.
I think Thomas is the most, approachable, I would say, the most digestible justice.
Yeah.
Well, approachable from the average person can read his opinion, and it's very clearly stated. You don't need to understand a bunch of legal terms, but from just erudition and turn of phrase and things like that. Kagan's
Yes.
excellent with that.
I
Um,
also, but her opinions are also not, I don't find them very hard to read. Like I
no,
generally, I judge them on how douchey their writing is. I don't find her to be that way. I don't even find Thomas to be that way. I could hate his opinion, but I'll like the way he writes it. But Alito, it's just like every time I read it, I'm just like, I hate this guy. Like it just gives me the ick.
no, I'm with you there. So Kagan's arguing that the TPS statute bars review of the secretary's ultimate country condition determination, but it doesn't review whether the secretary complied with mandatory procedures, such as consulting appropriate agencies. That came up a lot in the oral arguments. Um, And yeah, I think the racially charged statements by the president were an inference that race was a motivating factor, so that there was a valid equal protection claim. I'm definitely with this. Again, this is just a textual cop out. When you have a real demonstrable issue, but as long as the government can articulate that they followed the plain text, that they get enough. It's the same thing with the Louisiana Calais. It's, hey, yes, it's very clearly racially impactful, but the text says that you have to prove racial intent, and that's a little bit that's problematic in under this presidency.
Well, and to be clear, the question that was actually argued in this case, and there was another case dealing with Haitian nationals, so I believe this was also the answer to that because the questions were exactly the same. It's not listed anymore, which is weird because I remember doing both cases. Is
Were
whether
they
the Trump
consolidated?
Yeah, I think they were, and I think this may be why this went down this way. But there were Syrian and Haitian nationals. One case addressed Haitian nationals, one case addressed Syrian nationals. I believe they did consolidate the argument. I have to go check my YouTube to see if
Yeah,
I marked it
no, I think that's right
consolidated.
because this is yeah, it was consolidated. So this
Okay.
was Trump versus Moit and Mullen versus Doe. So they were consolidated. That's why it's addressing both the Syrian and Haitian claims.
I just want to give a quick shout out. Like, so many people have come in and liked and shared and gifted and all the things. And I appreciate you all so much for that. That's amazing. And I love you for it. Definitely gift law. And if you're not following law, you better be following law because he's in my lives a lot, but like he also does like his own shit and his own videos and like he does his own lives from time to time. He's amazing, a wealth of knowledge. Please follow him if you're not, and gift him and all the things. Oh, and by the way, I have to gift you because I can never gift when I'm in studio, but I'm on my phone now. So there you go, Law. I got you. Um, but yeah, so they've only dropped 4 decisions today, which means we still have 8 decisions left. So maybe we'll get another Tuesday, Thursday next week, potentially. I don't even see them dropping 8 decisions in a day. That seems like they might want to torture people. Like maybe we'll get another Tuesday, Thursday, and then they just skedaddle for July 4th. Maybe.
Yeah, they've done three in a week before. So
Yeah.
they might have to do like a Tuesday, Wednesday, Thursday. They've done that before. But yeah, they're running out of time. We've got what, 11 left, 12 left, 12.
I'm I'm telling you, I really think they're gonna eviscerate, like you said, and I hadn't considered it before, but it made so much sense when you said it. They're gonna eviscerate him on birthright citizenship, and they are gonna hit the fucking road. Like they are
That,
gonna be like, I'm out, motherfucker. Like I gotta go.
that's going to be like Dobbs. Like, well, actually, Dobbs came out early because of the leak, but
Well, Alito leaked it. Yeah.
yeah, but when they drop these big earth-shaking decisions, especially if it's against Trump, they're going to be far away from MAGA. They're going to be on their planes to Europe. It'll be like, hey, we dropped it, we read it. Marshals, get us to the airport.
Well, I also wonder what they're going to do on the mail-in ballots. That was one that was closer for me as well because It was very, it wasn't as close as I believe I was telling somebody else. There was one other decision where I was like, I don't know how they're going to go with this. I have no idea. It's going to be super close. But the mail-in ballots, we have the campaign finance case, or not campaign finance, but like a party expenditures case, Citizens United 2.0. We have Trump v. Slaughter, Trump v. Cook, and Birthright. So have a lot of swift kicks to Trump possibly coming. But the mail-in ballots one, if they let me down on that, I'm gonna lose all faith law. Like, because sometimes you just have to read an Alito decision and go along with your day. But if they let me down on that one, I'm gonna lose my mind.
I just can't, from the oral arguments, I can't see that happening.
I know, but it was kind of, it was murky. Like, that's all I'm saying. It was murky. Like,
yeah, but I think the statutory violation is so clear on it, that there, if nothing else, I'm iffy if they're going to try to reaffirm ARC or anything like that, but at least on the statutory grounds, it's got to be 6-3 or 7-2 at least.
Oh, not the birthright on
the mail-in ballots. I'm sorry.
The ballots, yeah, the ballots.
Yeah, that one. Yeah, I'm with you there. That's that the oral arguments were convincing, but that one is lined up for a heartbreak.
I know, and I just can't take any more. They've just been hitting me where it hurts, and it's not cool. So what else are we waiting on? So we'll go through the ones we're going to still be waiting on. Waiting on Trump v. Slaughter. We're waiting on Citizens United 2.0, which is the National Republican Senatorial Committee versus the Federal Election Commission. We are waiting on the 2 cases involving transgender athletes. I've already told y'all I don't think this is going to bode well. Based on the arguments presented, which is Little v. Hecox and West Virginia versus BPJ. We're waiting on Trump v. Cook, Watson v. Republican National Committee, which is our mail-in ballots case, and then birthright citizenship, and Chattery v. U.S., and we already got Mullen v. Doe. So, yeah. That's where we're at. I was thinking we might get more decisions today, but we did not. So that's where we're at right now. Any other thoughts, Law? I just 3 Alito decisions in a day is just weighing on my soul. I don't have much. Oh, he may be in Zoom court, so we'll leave him alone. But anyway, guys, so we got the Monsanto decision. Basically, they say, fuck you. You can't sue. We got Mullen v. Doe, and basically they told TPS seekers, we don't care if it's racial, fuck you. Oh, I'll let Dave up real quick. And then we have Mullen v. Al Archulado, which said they're still on the Mexican side of the border, so fuck them. And then Wolford v. Lopez, the only decision that I was like slightly excited about, which said, hey, they can't make you like get permission to just go about your business like a normal human being with your firearm. What's up, Dave?
Oh no, the Hawaii decision was excuse me, was interesting because I have a feeling a similar thing's coming up in New York, because we here
I
in
saw
New York
your
City.
suppressor one.
No, thank you, but that's in the Fifth Circuit. I'm talking
I
about
know,
the
but
Second Circuit.
I understand that. I was saying I saw your suppressor video. So what's going on in New York?
Well, we have these things called subways, and after Bruin, the city issued a law that said that there are sensitive areas where even if you can carry, you can't carry. There's a case called, I think it's Frey v. New York or New York v. Frey, where a stay was requested. It was denied by the Southern District of New York. Then it was denied by the Second Circuit. I think that's going to be coming up in the next session. We're going to see that. That one's going to be interesting because historically, because the Bruin standard's all about history. Historically, it's all about whether historically there were areas where you couldn't carry, and historically it was only, I think it was government buildings and polling places where you couldn't carry. Neither of them are government buildings or polling places. And most of these sensitive areas are not.
Can you send me the background on it, or just like some documents? I want to take a look at it. I hadn't heard of that, but I want to take a look at it.
Sure, it's Frey v. City of New York.
Hold on, let me
Second Circuit for Frey, like the phrase of Westeros.
Okay.
You want the? I can give you the.
I got it.
You got it? Yeah.
Yeah.
Yep. It was decided September 19th. I can't see anywhere whether anyone even asked for cert or whether cert was granted. I looked a little bit. So that one's going to be interesting. There's also the case out of, I think, Connecticut, which is going to go to the Supremes regarding the 10-round limit in implements. Did they
take up cert on it?
I don't know, but I know that it's being litigated. I know that's coming.
Until they actually pick up cert, I like they piddle around like so hard. But I know they said, Brett Kavanaugh said like a session or two ago, we want to address like AR bans and mags in the next 2 sessions or so. So I'm expecting we may have something in the upcoming season, the Real Housewives of Scotus. But it's never a guarantee with the Trump admin and all their shenanigans. They may not have time. So we'll see. But they did grant review on 6-person juries, which I am actually excited about. Neil Gorsuch is my wild card. He's my baby. I can change him. Kind of dude for me. I know that's weird, but I love his voice. And even though I don't like all of his decisions, it's like, baby, I can change you. Like we can make this work. We can make this work.
I hate to tell you, I don't like many of their decisions. Sotomayor, who I usually adore, decided one of my least favorite cases, Keto v. New London. I hated that case, and it turned out to be trash anyway. It was a eminent domain case where the city of New London in Connecticut wanted to take eminent domain, and somebody's like, "No, I don't want to fucking sell. Screw you." And they took it anyway. It was it was horseshit. It gave municipalities way more power than they should have on eminent domain. And it turned out that it was all trash. The stuff that New London took over turned out to be trash anyway. But it was and Sotomayor, I love Gorsuch's pro Native American decisions, even though they were he was in the minority.
Well, I like that Gorsuch is one of those people that he throws me like something sometimes where I'm like, I know he's a human. Like he may be a textualist and I cannot agree with some of it, but I will say he's at least committed to his textualism. Like he doesn't waffle on it just because he doesn't like the outcome of something. I can respect that he's committed to it. And also, I like that he's been bitching about wanting to hear a 6-person jury case. Like that's part of something he's wanted to hear. So I can at least respect that.
And because you brought it up, I have to say, Samuel Alito, despite his friendship with RBG, screw him, because he was a textualist when he wanted to be a textualist. I thought Scalia was friends with RBG, not.
Oh,
Scalia. I'm sorry, not Alito. Scalia. Yeah, that's what I'm thinking.
That's granddaddy originalism. So don't be stomping on Scalia's name. I can hate that motherfucker, but it's still
F him all day long. F him because he was a hypocrite. He was a textualist and originalist when he wanted to be, when the result was something that he wanted, and when he didn't want that result, he got real creative, incredibly creative.
Interesting.
Right.
I mean, I'm not saying you're wrong. I'm not saying you're right. I just I've always liked Scalia's writing style, but more than that, I always liked that he had a law clerk that had like opposing views because it like he felt like it kept him honest. That was something I always at least liked about Scalia.
Well, that's that. Yes, he was a very smart guy. He was he was a scholar, unlike Thomas. Sorry, can't stand that man.
No,
He was
it's
a
okay. Like,
scholar.
I mean, this is the thing. It's like we can love to hate people, right?
Oh,
Like we
yeah.
all have those people that we can kind of like love to hate. Well, I don't agree with some of Scalia's decisions. I can respect things about him, and that makes me like him, but love to hate him. You know what I mean? Like it kind of works like that.
Absolutely. Oh,
But anyway,
absolutely.
I am gonna like wind her down because I got
All right.
kiddos and they're wanting to do things. But Dave,
Sure.
thank you so much for coming up. Law, if you can hear me, thank you for coming up, and we love you for that. And have fun with Zoom Court. And everybody, thank you so much for coming in. You're amazing. My kids are now talking in the background because they're like, "Mom, come on." So I love all of you, and I want you all to have a good day. And when we know when Scotus is going to release more opinions, I will let you know. Bye,
I need to
guys.
say this, Mom. Bye.
Bye.
Look at the guy that will